The judge told me when I went to court on Wednesday night.
What was on video?
They said they have a video of me and Cassius Bond in Tennessee.
Okay. I don't get access to any of that. Right here, all we were worried about is identity. Are you Naomi Burnett? And if you are, we establish the identity, that the charges are proper. If so, how do we go forward? A lot of times we let someone bond out if the person is not a danger, right? And we know that they're going to go back. But we don't know much about you, you know.
I have no criminal record. I have a degree, a bachelor's degree.
Hi, Ms. Burnett.
Hello.
Okay, so it looks like you're wanted somewhere. I don't know where.
One out of Rutherford County, Tennessee. Warrant was issued out on September 9, 2024 for 3 charges: theft of property $60,000 to $250,000, and identity theft of at least 10 counts, and a fraudulent use of $60,000 to $250,000. I will obviously be opposed to a bond. She already waived on November 20th.
Does she have an open local as well?
No, Judge.
Why did it get reset so much?
I do not know. Well, it was carried over.
Oh, it was carried. Okay. Ms. Oko.
Judge, so Ms. Burnett does tell me that she's a victim of identity theft. So she's believing that this is just stemming up from someone else using her identity to do different things that she has no, and she did write a report on this, I believe, a few weeks before this charge came down on her.
So you're telling me that the felony capias and the $60,000 to $250,000 theft of property and the 10 count identity theft, the fraudulent use of a debit card of $60,000 to $250,000, all that was someone else?
Yes, Judge, that's what I'm being told. Ms. Burnett, go ahead.
Yes. So last year, I already filed a police report against Cassius Bond. He stole my social security number and he used it to open up an electricity bill in my name. And I also have other charges against him regarding burglary of inhabitation. He broke into my house and stole my phone, and he stole money from me. And he also put his hands on me. So I'm guessing these charges are from him. I've never been to Tennessee before in my life.
How do we verify that?
I've never been to Tennessee?
No, well, I mean, the problem is that, you know, a lot of people tell me something, right, when in fact the sky is blue instead of purple. People come in here, tell me, yeah, the sky's purple. Man, this pig was blue. And what? Pigs are pink. Yeah, man, this pig was blue. You got to believe it.
I have proof of being in Houston on those dates, whatever dates they're saying.
Okay, so I guess, I mean, I could have you get with the lawyer somehow, you guys. I mean, we've given you a lawyer. She's here to help you out in whatever manner that they can. I would suggest that you guys get together to figure out how. That's a lot of baggage. I mean, that's...
Yeah, I was working with the assistant district attorney. We were pressing charges on him. So I didn't know he was out of jail. He was supposed to be in jail still.
I mean, I guess I can have you guys talk about it. You've already waived, right?
Yes, Judge.
Do you know if Tennessee's going to come get her?
As far as I know, they are, unless they tell me different from 5 days ago. But the waiver was sent on the day she signed with the magistrate, so they would have told me.
You basically have 9 days left.
And with the nature of the offenses, they can be done remotely because their identity, the very nature of the offense is that they could be done remotely. And if it was similar to conversion for the theft of property, they could have occurred from here, but the impact in Tennessee.
Here's the deal. We give the other jurisdiction 14 days to come get you. You've already been sitting in there and you waived already. So they only have 9 days to come and get you. If they don't come within that time, Harris County releases you. So, but I'll tell you, even if Harris County releases you, that warrant is always going to remain out there until you go back to Tennessee and try to take care of it one way or the other.
I don't mind going to Tennessee. I have transportation. I just don't want to remain in custody.
I know. No one does, right? But
and I was told there was some type of video, so I don't see how it could be electronically done.
Also, it is worth noting that I never.
We don't know. We're speculating. We don't know.
The judge told me when I went to court on Wednesday night.
What was on video.
They said they have a video of me and Cassius Bond in Tennessee.
Just give me a second, Jake. Okay. I don't get access to any of that. Right here, all we were worried about is identity. Are you Naomi Burnett? And if you are, we establish the identity, that the charges are proper. If so, how do we go forward? A lot of times we let someone bond out if the person is not a danger, right? And we know that they're going to go back. But we don't know much about you, you know.
I have no criminal record. I have a degree, a bachelor's degree.
But
So if it's a matter of verifying the identity, if she's contesting identity, then she can withdraw the waiver and we can go for a governor's warrant. Or
I don't think she's contesting identity. She wants a bond, is what she
so, like I
wants.
said, with the amount in the offense, with $250,000 on both theft of property and fraudulent use of credit card, and the fact that it's 10, which would be a third degree or second degree felony here, is that I'd be opposed with the sheer amount that is being alleged.
Yeah, one of the other things is.
All right, pause right here. This is a critical moment in the courtroom. The judge isn't just being cautious. Legally, when someone faces serious felony charges and large financial allegations, the court has to consider the risk that the defendant might flee before trial. That's why bond decisions can get complicated. The judge is basically saying, before I let you walk out of here, I need to know you'll come back. What do you think? Should courts be stricter with bonds when the charges involve large amounts of money like this?
Is able to answer up to those charges. So
I also say that I already have a lawyer ready in Tennessee.
So what we can do here, what we can do is I can have you talk with Ms. Oko, figure out if there's some way that you can show that it's someone else, right? And if so, then we can talk more. Okay. But understand that I can't just take your word for it, you know?
Understand?
Okay. So
even if I have police reports on him for already stealing my identity.
I'll let you talk with Ms. Oko, see what you can formulate, craft some kind of plan so that they're satisfied and I'm satisfied, and then we'll go from there. Okay. It's not a no. I mean, it's an uphill battle, but it's not a definite no at this point. Okay.
Understand.
Okay. Yeah. All right. Thanks. And you know, just give me a heads up if you have anything, you know, different. Ms. Wickenhofer, in the flesh.
I know, right? We're famous, by the way. Over 30K people watch it. Anyways, it doesn't matter. I have to read off my phone, so I apologize, but
It's okay.
it says, Your Honor, I was convicted of driving while intoxicated in this court on October 14, 2019, under cause number 222. You already got it. I was sentenced to 4 days in jail, and I have completed that sentence, including paying all fines, costs, and restitutions. I am here today because I meet all the legal requirements under the Texas law for non-disclosure of this conviction. Specifically, number one, my conviction was for DWI with a blood alcohol level below 0.15, which actually was 0.11. I specifically remember. I was not placed on community supervision for this offense. This offense did not involve an accident with another person. I finished my sentence over 5 years ago. I have not been convicted or placed on deferred adjudication for any other crime except for minor traffic violations. This conviction from 6 years ago is still hurting my reputation and my ability to grow in my career. I deeply regret my actions and have learned from my mistakes. Since then, I have worked hard to turn my life around, and I am asking for a second chance. Granting this non-disclosure will allow me to fully move forward, both personally and professionally. It would help me reach my potential and improve my future. Thank you.
Absolutely. So I don't think I can. Show me where you think I can, you know, but non-disclosures are traditionally for people who take deferreds, complete the deferreds, and are eligible to have it sealed. Expunctions are for those that meet the requirements where if a case gets dismissed, they can have it expunged. Here, when you plead guilty, I don't think you're eligible for either. And the thing about it, I can't give you legal advice. I can't tell you how to look this, how to look that. But if you have a piece, or if you can show me the law that says I can give you a non-disclosure, and I can tell you, Ms. Wickenhofer, I love it, and I've told you this before, I love it when people try to better themselves, right? If I can, I will, because I'm always about trying to make someone's life better, right?
Yes, sir.
But I have to follow the law. I can't just say, okay, I can't just rubber stamp and do it just for the sake of doing it. There has to be a law, because if not, they appeal it and I'll get overturned.
Yeah, I think
That's
yeah,
what
I think it was
traditionally
the
happens.
points I said, because I was under a certain amount of alcohol in my system.
That doesn't, what matters is the ultimate result in the case. Did you plead guilty? Did you do a probation? Did you do a deferred? I think that the legislature even now made deferreds available for certain types of DWIs so that people don't get convictions,
I
right?
understand.
But, we never do them, right? But you can, right? And it's surprising that no people do deferreds on DWIs.
Traditionally in Harris County, Judge, we don't even offer deferreds on DWIs.
But if theoretically, if you go without an agreed recommendation, we could, and I think that we may have. I don't remember, but
So they don't
to-
grant deferred here then in Harris County.
no, you can.
You have to pay more money, so it sounds
You
like.
know, it's not about money. It's about, there are other options that are better
Okay.
for some. So
I think that's probably why I didn't do it, because they didn't give me the option to.
we always do, though. Every single case. I talk to every single person that comes up here, and I make sure, hey, look, you're making a lifetime decision. Are you sure that you want to do this? Because it's not Target. You can't return it once you do it.
Yeah.
I literally, every person I scrutinize, micromanage. That's why we're
Now, this is where things get really interesting. She's asking for something called a non-disclosure, which basically means sealing the record from public view so it doesn't keep hurting her career. And listen carefully. She's arguing that her blood alcohol level was below 0.15 and that she completed her sentence years ago. Emotionally, this is a powerful plea for a second chance. But legally, the judge has to look at something very specific: how the case originally ended. Did she plead guilty, or did she receive deferred adjudication? That tiny legal detail can completely change the outcome.
disclosures. Who is eligible for them? You have to read it. You got to digest it. You definitely are not. I don't think you're. I mean, I can't give you legal advice, right?
Yeah, I understand. It's something we could do, but I don't know. I just want something to be done. I just don't know what can be done. It doesn't sound like anything, which really sucks for me, but.
Us. Yeah, and the thing is that I even tell people that, within a certain amount of time, if you get buyer's remorse, within 30 days of doing something, we've really reopened cases for people who get buyer's remorse. But here, the case is 5 years old. I have no jurisdiction. Even if I wanted to reopen it to do something, I can't. The only advice
Any community service I can do, like any extra thing I can do.
What I would do is really go to a lawyer. You're going to have to spend a little bit of money. Go to a lawyer and fine tooth comb non-disclosure law
Okay.
and see, is there an out? Is there this? Is there that?
Mm-hmm. Just ask questions. Okay.
You may have to hire a lawyer to really dig into it to see what you can do. Okay. But I can't give you legal advice. I can't sit there and comb the code with you to see, is there a provision that would get it? Because there's so many little nuances here and there. Right. I mean, even so much as a 0.15 or above or 0.15 or below, how long it'll suspend your license versus this. There's just so many little nuances.
The judge clearly sympathizes with her. He even says he wants
so
to
sorry.
help if he
It's
can.
okay. What was that book called again?
Judges aren't allowed
Code
to
of
make
Criminal
decisions
Procedure.
based
Okay.
purely
All right.
on
So,
Thank
you know, and
They're
right,
bound by
Google
the law.
Code of Criminal
And
Procedure,
according to what he's explaining,
Texas
once
non-disclosure,
someone
you know,
pleads
and even if you
guilty
do that in
instead of
Google,
taking
you'll
a
have so many
deferred
other lawyers'
adjudication deal,
sites.
their
Read
options
through
for
all those.
sealing that
Okay.
record
But I
become
don't think that I can.
extremely
You know, once you plead
limited. It's
guilty,
a tough
that's
lesson
it.
about courtroom
That's
decisions.
that's
Sometimes
why
the
I caution
easy
everybody,
option
when
in
you
the
take the
moment
easy
can
way
follow
out, when
you
you
for
do something like
years.
this,
Let me ask
it's a
you,
lifetime thing.
should the law
Yeah,
allow
I
more
understand.
second
Thank you.
chances in cases like this?
Sorry, Ms.